We've all seen it in Hollywood criminal trials. Defense counsel gets up and says, "Objection, Your Honor, relevance." That's an interesting question. What's relevant? What's not? How does evidence get admissible? The topic for today, and it's a great topic, is what makes evidence inadmissible in a Canadian criminal courtroom? Great question, and I'm going to try and break it down. I'm going to go through some categories. It's a very complicated topic. You have to know the rules of evidence, but let me just go through some categories with you. Well, first of all, we have a constitution in Canada. It's called the Canadian Charter of Rights and Freedoms. And if there's a charter violation, then evidence can potentially get excluded from the trial. I'll give you a couple examples. So let's say there's a search and seizure of a drug house and the police didn't really have a proper warrant, and the defense counsel properly challenges under Section 8 search and seizure, gets it excluded under 24(1). The drugs never get admitted, so that evidence is excluded at court. It's not admissible. Let's say there's a rights to counsel violation in a murder investigation where the police did not give the accused the proper rights to counsel, never allowed him to talk to a lawyer, which is a pretty obvious violation, and then derived a confession from him. Well, that confession is going to get thrown out under Section 24(2) if it's a serious rights to counsel violation. So charter violations, it's a very complicated area. I just gave you two very simple examples. Now we're into all sorts of other evidentiary rules which arise from the common law, like literally hundreds of years of cases. And as a lawyer, you have to know this, first of all, instantly in a courtroom, intuitively when you hear someone speak on the witness stand, but you also have to know the law to back it up. And it's a complicated area, but I'll break down some simple areas. So first of all, there's the confession rule. In order for the Crown to introduce a statement from the accused, whether they're going to introduce it as part of their case or whether they're going to introduce it to cross-examine the accused when the accused testifies, that has to be a voluntary statement. No threats, promises, or inducements, no oppressive or coercive circumstances. So the Crown has to prove it. Sometimes defense counsel will challenge this and get a statement thrown out. There's a second category. Now we're into other categories such as relevance. This is a very important one. Obviously, in order for a piece of evidence to be admissible at court, it must be relevant. We don't start talking about court. If someone's charged with a murder, we don't start talking about what they were doing 3 years ago on a Wednesday, that they were, mean to their wife and said mean words, as an example. Crazy example, but I've seen crazy stuff try to be introduced in courts in the past. So that's not relevant. Relevant means it's proving, it's germane to the case, and so that's a very important concept. Relevance is its complete own concept. Evidence cannot be, let's go to a third category. Evidence cannot be unfairly prejudicial. It must be fair and relevant evidence that's not prejudicial. A judge has to weigh a probative value of the evidence versus its prejudicial effect, essentially. That's a whole area of case law as well. We also have privileged communications. Sometimes communications between wives are not relevant, and husbands, if there's been a confession from one or the other. We have all sorts of other rules about what's oppressive and not, or what should not be introduced. It's a real major topic. But the bottom line is evidence has to be relevant, it has to be fair, and it's assessed on a case-by-case basis. So when you hear a witness testifying, for example, as a lawyer, you have to intuitively know right on the spot whether that's relevant or not, because sometimes the Crown, either intentionally or unwittingly, the witness is about to say something that's not relevant. You have to be on your feet objecting, and that's a study in itself. It takes, years really to learn, really to be a very good courtroom advocate and know intuitively what to challenge and when to challenge on the spot and when to give up on it as well. Some of these challenges are done in pretrial applications. We try and work out what's going to be admitted in court. Sometimes, and that can sometimes, on a big case, that can take several weeks, where you're bringing charter applications where the Crown's arguing certain evidence is relevant or not. You're trying to argue it against it. It's a lot of written argument, oral argument before the trial even starts. Sometimes it's evidence that's introduced during the trial that you're objecting to, and the judge in that case has to make an immediate ruling in front of a jury, or if it's judge alone, whether the evidence goes in or not. But it's important to object right away to irrelevant evidence or evidence that's not admissible in a Canadian courtroom. So we have all sorts of rules, all sorts of case law, charter. It requires extensive study, and that's obviously an important reason to hire an experienced criminal lawyer when you're doing this, because As a layperson, you're not going to understand the complexity of it. It's just, it took me years to fully understand it, frankly, as a young lawyer, where I was just intuitively able to object on the spot. It takes several years of study and practice and time. That's the bottom line. So there you have it, about, a basic primer about inadmissibility of evidence in a Canadian courtroom. I really appreciate you joining me today. And if you've enjoyed this video, I'd love you to subscribe to our channel, and we'll see you next time. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.